The court issued an order today with respect to the New York Times Rule 54B request to enter final judgment. It's a little bit complicated, but basically what the court is saying is that Lively's motion for attorney's fees under 47.1 constitutes the type of motion that could pause an appeal. The court explains a complicated interplay between the federal rules of civil procedure and the appellate rules, and the timing and the triggering events that cause certain things to happen, and is basically treating the motion for attorney's fees as a motion that could pause an appeal, meaning that the timeline for an appeal would be kicked off from the time the judge rules on that particular motion, not when final judgment is entered. In other words, the court's decision on Lively's New York State anti-SLAPP fees and the California 47.1 fees, he needs to decide on those. Even though he's going to enter final judgment as to the order and as to the New York Times, he needs to decide those before an appeal can take place. And that's because it serves judicial economy to take up the issues all at the same time, rather than say have the New York Times or somebody appeal the New York Times order at this point and then later have an appeal related to the fees. And so having them all be appealed at the same time would be more efficient for all the courts involved. So he's not ruling on the fees motion. He's saying that I will rule on the fees motion before the timeline for appeal gets kicked off. So when everyone was wondering why the Wayfarer parties didn't oppose or respond to the judge's order to show cause, it's because they agreed that Lively's fee motions should constitute a fee motion under the particular set of rules that the court outlines. And so with that configuration, they now have additional time to appeal once the court finally decides and submits an order with respect to the fees motion. To put it more simply, the judge isn't in any rush to be deciding on the attorney's fees and won't be doing it until likely late into the case, which means that kicks out the time that Wayfarer would have to, if it decides to, appeal the June 9th order. And had they filed something, it would be one sentence, which is really not necessary. So they didn't file anything, the New York Times didn't file anything, Lively made her piece, and the judge decided that this is how he's going to rule.